Hey folks, I'm attorney Andrew Branca from the Law of Self-Defense. So, you wake up in the middle of the night, you go downstairs because you heard a weird noise, and there's some dude you've never seen before sitting on your couch. Can you just shoot that guy? Let's talk about it. So, this topic was brought to my attention because I saw a tweet just this morning on X, and I'll share that with you here. Pop it up on the screen, and it reads, it's from a gentleman called Jeff Feldman, whoever that is, and he writes, text from an LA group chat, LA being Los Angeles, it's real. The cops won't come because it's not an emergency. And then he embeds the chat he's referring to, and it reads, who can we call for help? There's a stranger lying on my couch in my house, and he's refusing to leave. We called 911. He's saying it's his house, and he's refusing to leave. And the cops, folks, declined to come because this was not an emergency. No one's life was being actively threatened. This is your problem. Now, it doesn't say what time of day this was, although the time in the chat's 8:50 p.m. But let's imagine it's the middle of the night. The scenario I described at the start. You hear a noise, you go downstairs, you bring your gun because you're prudent. You went downstairs maybe because you're not so prudent, but in any case, you went down with your gun, and there's a dude on your couch. What can you do with that dude lawfully? Can you shoot him? Well, let's think about under what circumstances you can normally use deadly force in self-defense. The correct legal question in that context is this person reasonably perceived by you as presenting as an imminent threat of death or serious bodily injury? We're talking here about a dude sitting on your couch. Is that dude just sitting on your couch, doing nothing else, just looking at you? Is he reasonably presenting as an imminent threat of death or serious bodily injury? I would suggest not. In which case, the normal conditions for the use of deadly defensive force, the default conditions, the primary justification for the use of deadly force in self-defense have not been met. Now, do the rules change when we're talking about defense within your home, within your castle, within your highly defensible property? And the answer is they do. The extent to which they change varies a bit from state to state. In most states, if there's somebody unlawfully in your home and they entered forcibly, meaning they broke something to get in, there is a legal presumption that that person is reasonably perceived by you as presenting as an imminent threat of deadly force harm. And that really gives you all the elements you need for the lawful use of deadly force in self-defense, or at least most of them. It allows for a reasonable perception, which is the element of reasonableness, one of the 5 elements of self-defense, that he's an imminent threat, that's the element of imminence, that the nature of the threat is deadly in nature, that's proportionality. Now, avoidance is not covered there, but avoidance is covered in every state under the Castle Doctrine. You're never required to retreat from a threat, a genuine intruder, when you're in your home. The only of the 5 elements not covered is innocence. But innocence is kind of baked into the cake when you're in your home and you're dealing with a forcible, unlawful intruder. Now, that is a legal presumption. The presumption is generally rebuttable, meaning it can be overwhelmed by countervailing evidence. So, for example, if the forensics evidence, you shoot this person and the forensics evidence afterwards tells the authorities that he was actually face down on the ground and you shot him in the back of the head. That would be the kind of evidence that could rebut this legal presumption that's otherwise very much in your favor. Now, generally, not all states that have this legal presumption, but almost all of them require both an unlawful presence and a forcible entry. They broke something to get in. Why do they require both? Because they're concerned about what we might call the innocent intruder. That is someone who's present unlawfully. They don't have license. They don't have permission to be there, but they're there without malice. How might that happen? Well, it could be a repairman sent to the wrong address. He's told, hey, these people need their dishwasher fixed, but they can't be home. They have some other obligation, so they're going to leave the back door unlocked so you can get in and fix the dishwasher while they're out. And then they send that repairman to the wrong address. So he gets to the wrong house. Sure enough, the back door is unlocked. He walks in. He's an innocent intruder. He's there unlawfully. He does not have permission to be in that house, but he's there without malice. Another example might be out-of-town guests visiting someone who lives in one of these apartment or condo complexes where all the apartments basically look the same. I know I've lived in places like that. And they go out in town, maybe they have a few drinks, they come back, and they walk into the wrong apartment, completely innocently. They think they're walking into the correct apartment, but it's the wrong apartment. So now they're unlawfully present. They don't have license to be in that apartment, but they're not there with malice. They're not there to commit some criminal act. So there can be innocent explanations for why somebody's in the wrong place without permission. But there can't really be an innocent explanation for why they would have broken something to get in. So most of these presumptions of reasonable fear require both unlawful presence and forcible entry, that they broke something to get in, to ensure that we're not dealing with an innocent intruder. The law does not want to give you the benefit of this legal presumption if you could simply ask the person to leave and they would leave because they realize they're in the wrong place. Often, there's also another legal presumption. The first legal presumption I just talked about has to do with the defender's state of mind. It presumes the defender had a reasonable perception of an imminent deadly force threat. A second presumption often has to do with the intruder's state of mind. It's legally presumed the intruder is unlawfully present to commit some violent act against an occupant of the dwelling. These are all things, of course, that would be instructed to the jury in a trial where you'd be charged for use of force in defense of your dwelling. Very helpful to the defense. It makes a home defense scenario very difficult to screw up for the defender from a legal perspective. Although people do manage it, right? If you chase that guy out of your house, down the street, and shoot him in the back while he's running away, now you're no longer defending your castle. You don't longer get the benefit of that legal presumption. Colorado, where I happen to live for the moment, for a few more months only, I hope, has perhaps the most interesting defense of home statute. The laws I just described legally presume that the elements normally required for self-defense, innocence, imminence, proportionality, avoidance, and reasonableness, it presumes they're present, but that presumption can be rebutted. Colorado has a statute it refers to as the Make My Day law that simply does away with one of those elements, the element of proportionality. It allows you to use deadly defensive force, not because it's presuming you were facing a deadly force threat, but in the explicit absence of a deadly force threat. There need not be any deadly force threat to authorize you to use deadly defensive force. And this occurs when someone unlawfully enters your home and they threaten any occupant of the home with any degree of force. That could be a finger poke to the chest, and that authorizes you to use deadly defensive force in that circumstance. So, what do we have now? We have this guy sitting on your couch. He's not making any explicitly threatening motions. He's not apparently presenting as an imminent deadly force threat. In many states, you would have the benefit of this legal presumption if he had broken something to get in, and you knew he had broken something to get in. So how would you know that? Well, maybe you heard glass breaking, maybe you heard wood cracking, something that would indicate to a reasonable person that you could infer that somebody was breaking into your home, because that would clear away the concern about the innocent intruder. But even with that presumption, again, it's rebuttable. So you can't simply shoot the guy, no matter what. It still has to be a situation in which you could do that and not have your legal presumption of a reasonable fear be rebutted. So what do you do if you're not going to just shoot this guy sitting on your couch? You ask him to leave? Maybe he's just silent. Maybe he's in a drugged catatonic state, doesn't even know you're there. Maybe he's just psychotic, and he believes this is his house, as apparently the person in the tweet I just shared believed. Maybe he genuinely believes that. Maybe he believes you're an intruder in his house. Of course, it's your house, and he's not entitled to be there, and he's a trespasser. Now, the law does not allow you to simply shoot someone just because they're a trespasser or not committing some other offense, but you're allowed to use non-deadly force to remove a trespasser. So if you were big and strong enough, could you just grab this guy by the arm, lift him off the couch, haul him to your door, and throw him out? Sure, that would be fine. If you're not big and strong enough, could you use non-deadly means of force, such as pepper spray or a taser or an impact weapon applied in such a way that you're not likely to cause death or serious bodily injury, like a baton to the legs, for example? Sure, that would all be permissible. By the way, if your plan is to use pepper spray for this kind of scenario in your home, in any space that you care about, I would encourage you to keep in mind that there's various forms of pepper spray. There's pepper spray that comes out as a mist. There's pepper spray that comes out as a stream. There's pepper spray that comes out as a gel. If I were in a place I cared about and I was about to deploy pepper spray, I would very much appreciate it if it were the gel form. Now, I wouldn't carry the gel form out on the street because the stream form shoots further, and I'd like more projectile weapon in my non-deadly projectile weapon. But in the home, for example, security guards in a hospital, typically when they carry OC spray, it's the gel form. So it doesn't just get sucked into the ventilation system in the hospital, it gets spread all over the hospital. You do not want OC spray all over your house. Trust me on this. So you can use non-deadly force means to remove this guy. You can call the police, and if you're in a place where the police are not overwhelmed or have not been demonized by the defund the police groups, don't have a George Soros prosecutor in their jurisdiction, they may show up and help you remove the trespasser. But as we see here in LA, you can't count on it. So you better have a plan in place for dealing with this kind of scenario if you're at all concerned about this kind of scenario. By the way, is it helpful in avoiding this kind of scenario to have and keep your doors locked, even when you're home? That helps keep out innocent intruders. It helps deal with this kind of scenario, and it compels whoever wants to get into your house to break something to get in. And now they're a forcible intruder. And that strips away any ambiguity that they could potentially be an innocent intruder. By the way, the guy sitting on your couch, and he's not explicitly acting in a threatening way, how much would he need to act in a threatening way before you'd be reasonably privileged to use deadly force in self-defense? Not much. Not in my house. In my house, if that person is literally just sitting on that couch or just standing across the room and not doing anything, just standing still, I'm probably not going to shoot him. Almost certainly I'm not going to shoot him. I just don't see the necessity. At least not in the moment. We'll see how things develop. But I wouldn't need to see much before I'd be willing to use deadly defensive force in my home against that intruder. If he reaches for his waistband, there's a good chance he's getting shot, even if I don't actually see a weapon. I don't have to wait to see a weapon. I have to be reasonable in inferring that he's about to present a weapon. If I tell him to stay back and he begins stepping towards me, he's probably going to get shot. If I tell him to stay where he is and his body weight shifts in my direction, he's probably going to get shot. So it'll be pretty easy for this guy to get shot. By the way, could this happen to any of us? Have any of you walked into the wrong building? Walked into the wrong apartment? Have any of you ever tried to get into the wrong car? I know that's happened to me. I mean, for many years, I drove a silver Toyota Camry, perhaps the most commonly owned car on the road. More than once, I went out into the parking lot, saw a silver Camry, tried the door, tried to get in. If I'd gotten in that car, I certainly instantly would have realized it's not mine. But meanwhile, I'm unlawfully present. I'm trespassing in that vehicle. So if it were any of us who were an innocent intruder, certainly we wouldn't simply want to be shot in the head for our mistake. On the other hand, if we were informed that we'd made a mistake, we turn and there's the homeowner with a gun in hand, you think we'd follow his directions? You think we'd be compliant? You think we'd leave? So as long as somebody's doing that, the intruder in your home, I would just let them leave. Don't get into fights you don't need to be getting into. But if they're not compliant, if they're argumentative, if they do anything that's consistent with presenting as a threat to you in your home, that should be enough. Because that strips away the ambiguity about them being an innocent intruder, doesn't it? All right, folks, that's all I had to share with you today. In the meantime, I'll remind all of you that if you carry a gun or own a gun in your home so that you're hard to kill, so your family is hard to kill, that's why I carry a gun, so me and my family are hard to kill, then you also owe it to you and your family to make sure you know the law, so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.